Hello, everyone. Welcome and thank you for joining our webinar, Practical Guidance on How to Mitigate, Manage and Overcome an Investigation in Japan, presented in partnership between the Legal 500 and Nagashima Ono and Tsunematsu, the Big Four Tokyo-based law firm. My name is Alan Cohen. I'm a research editor at the Legal 500. And before I hand over the webinar to our impressive panel, I will give a brief introduction of today's topic. So, as the title suggests, we will be discussing investigations, which are often associated with legal and practical issues for which they're not always single and straightforward resolutions. And in fact, in recent years in Japan, organizations of all sizes and sectors have had to manage internal investigations in response to an increase in white-collar crime and misconduct. So today our panelists are joining us to provide guidance on the practical steps that general counsels and risk compliance professionals can take to mitigate and even overcome the various stages of an investigation in Japan. So actually, let me introduce the panelists who will lead us through the presentation. So joining us is Ms. Ayumi Fukuhara. Ms. Fukuhara, do you want to say hi so our audience can see who you are? This is going to work. Anyway, I'm going to carry on the introduction. Ms. Fukuhara's main practice area is corporate crisis management and litigation, an expertise she's built through years of experience at the Ministry of Justice and at the Prosecutor's Office. Ms. Fukuhara is also experienced in matters involving foreign investigations and regulatory authorities, of course, and has dealt with cases in relation to investigations conducted by several national and foreign authorities, like the US Department of Justice, for instance. In addition, she's dealt with a variety of cases, such as data falsification in quality tests, accounting fraud, and other types of misconduct. And in parallel to working for the crisis management team, she has advised many companies on establishing effective compliance systems regarding personal information and trade secrets, BHR, so that's business and human rights, and anti-corruption, among others. Also joining us is Mr. Daisuke Fukamitsu. Mr. Hi. Fukamitsu, yeah, you already said hi, okay, hi. Mr. Fukamitsu's main areas of practice are white-collar crime, regulatory compliance, antitrust, and corporate crisis management. He has handled numerous internal investigations and related government actions involving alleged accounting fraud, cartel agreements, FCPA violations, so that's violations of the Foreign Corrupt Practices Act, and insider trading. In addition, Mr. Fukamitsu's covered both domestic and international cases across a variety of industries, including manufacturing, accounting, automotive, entertainment and media, financial services, corruption, and pharmaceutical. He's also a certified fraud examiner since 2012, a research professor at Shinshu University, and he serves as a member of the Research Committee on Governance Innovation at the Ministry of Economy, Trade and Industry. Our third panelist is Mr. Takeshi Hayakawa. Mr. Hayakawa, do you want to say hi?
Right.
Mr. Hayakawa is a senior associate lawyer at Nagashima Ono in Tsunematsu, who, since joining the firm in 2010, has gained extensive experience in national and cross-border data protection matters, including in investigation matters precisely. After graduating from the Duke University School of Law in the US, he was appointed the Deputy Director for International Affairs at the Personal Information Protection Commission, so that's a Japanese governmental commission, where he served between 2018 and 2020. So I'll hand over to our panelists in a moment, but before that, I would like to let our audience know that this session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A function at the bottom of your screen, and we'll put them to the panel once the presentation is over. Okay, then, Daisuke, I'm handing this over to you now. Please, feel free to introduce the topic further and lead the conversation.
Great, thank you. And let me share my slide. So can you see that?
Yes.
Okay. So hello, everyone. Thank you very much for coming to our webinar program. So I'm Daisuke Kamizu, a partner of NRT. First of all, we really appreciate Legal 500 for giving a good opportunity to speak about internal investigation in Japan. So this webinar is divided into 3 parts. So first, I will speak about the overview of internal investigations in Japan. Then my colleague, Ayumi Fukuhara, will give you a talk about supply chain investigation. Thirdly, Takeshi Hayakawa and Ayumi and I will have a session to discuss internal investigation and data privacy, which is really hot topic in Japan, based on the hypothetical. So let me introduce myself very, very briefly. So my practice area is generally focusing on global and domestic investigations and risk management and government investigation, defense and compliance and so on. And I have been a member of government committee to discuss and propose future dynamic governance model called agile governance to be adopted in a society where a high degree of integration between cyberspace and physical space is expected, and to solve problems that societies around the world face. In addition, I work as a research professor at one of Japanese national universities. And in this regard, I have been a host of white collar crime workshop since 2019, which is focused for businesses, practitioners, and academics to discuss topics around the corporate crimes, governance, and compliance. Well, let's move on to the substantive part, and I will speak about whether there is a statutory obligation or regulatory obligation for a company to conduct an internal investigation in Japan. In principle, there's in common with other jurisdictions, there's no specific statutory or regulatory obligations for companies to conduct an internal investigation. So the decision to start and conduct an internal investigation is generally discretionary matter. On the other hand, under the Company Act, directors have duties to establish and maintain appropriate internal control systems within the company. Also, as a matter of duty of care for senior management, if they do not conduct an investigation, even though they are aware of the realistic risk of wrongdoing, it could be a breach of their duty of care to manage and mitigate the risks and damages to be suffered by the company. In addition, in some circumstances, the company on reporting obligation to the relevant authority, such as the case of automotive recalls and unexpected adverse drug reactions. To carry out these obligations, companies should sometimes conduct an investigation. And in cartel case, in order to get immunity under the leniency programs in Japan, companies should conduct an internal investigation as soon as possible when they identify relevant risks. Therefore, companies in Japan usually will decide whether to conduct an investigation based on a variety of factors, such as credibility of allegation, evidence in hand, and scope and nature of potential wrongdoing, and damages to be suffered by relevant customers, and so on. Well, let's go to the next page. And when a company decides to launch its investigation, it usually starts from preliminary investigation by limited employees in compliance function to grab the picture of the case at issue and the possible impact and so on. And based on the information they obtained through the preliminary investigation, the company will then decide how to structure the investigation. As you know, there are a variety of structures to conduct an internal investigation. However, there's a unique practice, so-called third-party committee investigation in Japan, in order for a company to ensure transparency and accountability when serious corporate wrongdoings are identified. That is, the third-party committee is a body consisting of experts such as lawyers, professors, and accountants, and so on, who have no conflict of interest in the case. Although a fee and expense of the investigation will be paid by the company, since they are professional, it is regarded in Japan as more independent body to investigate the case than company itself. So the committee is established generally in cases where senior management are suspected to be involved and where the alleged wrongdoing attract public attention. In general, the committee will conduct an investigation for 3 or 4 months and create investigation report, which usually covers the investigation process, facts identified, causes of wrongdoing, and proposal of preventive measures. It should be noted that under this practice, the investigation report is usually made public. So we need to be really careful and we need to consider the risk of privilege waiver if the case has global aspect, and then there's a risk of government investigation in other countries outside Japan and risk of class action litigation. So then I will briefly explain about voluntary disclosure to enforcement agencies in Japan. Unlike in the United States regarding FCPA cases, where the DOJ, Department of Justice, has recently developed a so-called corporate enforcement policy that encourage companies to voluntarily disclose the case and facts and cooperate with investigation by giving some carrot, such as presumption of declination. So there's no such programs in Japan, except for leniency programs in the field of antitrust in a cartel case. But of course, as is the case of other jurisdictions, it is considered as mitigating factors when investigation authorities start their investigation. Also, voluntary disclosure could be an important positive step to establish a really good relationship with enforcement authorities. So this is also similar to other jurisdictions. Voluntary disclosure is very difficult, complex decision. So the company should consider the risk and benefit of disclosure based on various factors, such as the nature of the misconduct and likelihood of detection without voluntary disclosure, possible benefit so they can get by voluntary disclosures, and so on. And another unique aspect in Japanese investigation is non-existence of attorney-client privilege and attorney work product protection. As is widely known, in the field of investigations, attorney-client privilege and attorney-product doctrine are not recognized and established in Japan. And thus, it should be really careful in conducting an internal investigation in Japan and when having communication with enforcement or authorities in Japan. So please be noted that attorneys in Japan may refuse to testify and produce evidence based on their professional confidentiality duties. So therefore, the documents and evidence obtained by the lawyer and located in law firm is protected based on the confidentiality duties and the protections. And the problematic is a document including our memorandum or investigation report obtained by the company. So in order to conduct an investigation and with the protection of these confidentiality duties, so it's really important to carefully design the structure of investigation to mitigate the risk of privilege waiver. And you need to assign experienced counsel in order to conduct global investigation in Japan in an effective manner, especially when creating an investigation report, which is not protected by attorney-client privilege. And recently, there's a one step moving forward by the JFTC, Japan Fair Trade Commission. So they recently has established the procedures similar to attorney-client privilege. However, the protection is very limited. So we need to be still really careful dealing with the investigation. Well, then I will briefly explain witness interviews in Japan. So based on the employment relationship, so employees in Japan know their obligation to cooperate with an internal investigation. So company can ask employees to come to the interview and have can ask questions when it is needed. And unlike in the United States, there's no obligation for company or its counsels to give so-called absence warning. Also, it is not required for company to provide legal representation to witness. But in real cases, so as our investigator, so we usually give some explanation. So at the beginning of an interview to let them know, let interviewees know that their rights or their circumstances, so in the interview. And the interviews are generally conducted without a legal representative of interviewee in Japan. But in some cases, interviewees prefer to have his or her counsel during the interview. And in that case, so it is usually allowed to have legal counsel so during the interview. In addition, due to the pandemic, so many interviews are conducted online. So we should be really careful when having interviews online, since it may be hard to keep the confidentiality of investigation. So, and in some cases, interviewees or is in her or his or her home, and it is hard to control the circumstances of them, and we need to be really careful asking him or her, so whether there's anyone around him or her, or there's a camera, or there's a recording material, so something like that. So lastly, I will briefly explain the disciplinary action in Japan. So in general, legal protection for employees in Japan is much stronger than in the United States or other European countries. So it is so called the doctrine of abuse of right of dismissal. So in Japan, and while of course case-specific assessment is required, so it is generally not easy for a company to fire an employee, even though he or she committed some wrongdoings. So if the wrongdoing is not so serious, so it is really hard for a company to fire them. So under that doctrine, company usually should establish that disciplinary action is proportionate and equitable if the case is filed. One thing to be noted is that as is the case of other jurisdictions, we need to consider timing of disciplinary action, especially during the government investigation, since we may need some controls on the employee in order to fully cooperate with the government investigation. So in some cases, so the company decide to fire an employee who know almost everything the case, but so it's really hard when after releasing these employees to have an interview with them. So, and when we decide to cooperate in order to cooperate with their government investigation in an effective manner, so we need to wait for taking an disciplinary action against that employee, even though so fact is already identified and there's evidence. So that kind of practices is really important. Okay, so here we covered topics regarding the outline of internal investigation in Japan. So thank you very much for watching and listening to my slide. And so next presentation will be made by Ayumi Fukuhara. So she's focusing on supply chain investigation. So Ayumi, it's your turn. Thank you.
Thank you, Fukamidi-san. I'm going to show my slides. So my name is Ayumi Fukuhara. I'm a partner of Nagashima Ono Tsunematsu, specialized in global investigation and compliance. Among the compliance, I'm focusing on business and human rights. So today I'm going to talk about the supply chain investigation, which have become increasingly important in recent years for both for global and under the Japanese law context. As you may be aware, ESG, environment, social, and governance, is facing increased attention from various stakeholders, including regulators, investors, consumers, and NGOs, and it can pose legal, reputational, investment, and operational risks. In relation to this, Europe is ahead of other countries in the movement to legislate due diligence, including the recently announced proposal for a directive on corporate sustainability due diligence. However, ESG due diligence movement is also making progress in Japan, influenced by European laws and regulations, as well as international trends. Relatedly, in response to the request from their business partners in Europe and the States, Japanese companies are increasingly required to conduct supply chain investigations. Therefore, the growing need to address ESG risks is driving the necessity for investigation throughout the supply chain, in addition to the company's own business. Further, there is an increased economic security risks in response to recent international developments and political situations. Japan has not yet taken a clear position on the legislation of import restriction on the grounds of serious human rights violations. However, exports from Japan are actually at risk of export injunctions, etc., and greater transparency in the supply chain is required from that perspective. As for the recent movement of human rights due diligence in Japan, the result of the survey conducted by METI, the Ministry of Economy, Trade and Industry, and MOFA, the Ministry of Foreign Affairs, conducted a survey last year regarding the company's human rights due diligence. And the survey found out that half of Japanese publicly traded companies do not do due diligence on human rights. And of those who don't, around 30% said they do not know how to conduct such investigation. Since the survey was limited to the listed companies and the response rate was not high, it is likely that many more Japanese companies have not actually conducted due diligence. But among the supply chain investigation, human rights, which is positioned as S in ESG, increases the need for due diligence in recent years. Partly being pushed by the results of the survey, there are several recent developments of government regarding human rights due diligence in Japan. Firstly, in March this year, METI established a study group on guidelines for respecting human rights in the supply chain, which aims to publish the first guideline for the human rights due diligence targeting this summer. By creating this guideline, Japan hopes to close the gap between the United States and European countries, which are already responding to human rights concerns. The details of the guideline will be discussed in the study group, and actually I'm the member of the group as well, but there are many issues to be discussed in the future, such as how companies should identify and assess risks, and how companies should track and monitor and disclose their findings, and how grievance mechanism open to the stakeholders should be designed. In addition to the guideline, the Corporate Governance Code, which is an instruction established by the Tokyo Stock Exchange for listed companies, was revised last year. And the revised code requires corporate boards to deal with sustainability issues, including climate change and other global environmental issues, respect for human rights, fair and appropriate treatment in the workforce, fair and reasonable transaction with suppliers, and state that there are all important management issues that can lead to profit opportunities as well as risk mitigation. Further, companies to be listed in the prime market are required to meet a higher standard of disclosure, where the revised code states that those companies should enhance the quality and quantity of their disclosure in relation to sustainability, based on the recommendation of the TCFD, the Task Force on Climate-Related Financial Disclosures, or its equivalent. Additionally, according to the media reports, METI has recently requested ILO, the International Labour Organization, to dispatch experts to production sites in Asian countries like Cambodia or Vietnam to examine the human rights risks of the Japanese companies' overseas business partners and encourage improvement. Next, I'm going to talk about the characteristic of human rights risks in Japan. So in conducting the investigation on human rights risk, it is important for the company to understand the human rights risk unique to Japan. In general, the supply chain of Japanese companies has traditionally been characterized by multiple layers of subcontractors in the supply chain and low visibility of the supply chain, and the little substitution of procurement and production sites in the supply chain. Also, the Japanese technical intern trainee issues has widely used and invited many workers, mainly from other Asian countries. But this system is internationally very criticized that a trainee is often subject to a combination of high recruitment fees paid to the intermediaries, resulting in debt, and the lack of transparency regarding working and living conditions. Also, some companies are dependent on China and other Asian countries for the procurement and raw materials and components. Therefore, it is necessary to assess human rights risk from this perspective. Lastly, among all the industries, the textile industry is generally considered as high-risk area of human rights, as it has built long supply chains that range from manufacturing raw materials to distributing and selling them. METI established the sector-specific study group on sustainability of textile and apparel industry and publicized the report last year. In the report, the issues related to technical intern training and improving supply chain structure, formulating guidelines on design for environment have been pointing out, and the discussion is still continuing. I'll touch upon about the characteristics of the environmental risks in Japan. In Japan, as you maybe know, class actions are generally not as popular as in Europe, in the States. However, the issue of climate change has received a great deal of attention in Japan as well. Therefore, several injunctive actions against coal-fired power plants have been filed by local residents. Next, with the growing concern of the authorities about the environmental risks, there have been several cases of enforcement actions against fraudulent practices that do not meet their standards for the environment. Additionally, a few years ago, there was a series of quality data falsification cases that received major media coverage. And many companies should have looked into whether they had similar issues at the time. But even now, there are still a number of similar cases reported. In many cases, companies are required to investigate and deal with authorities, not only in Japan, but also in other jurisdictions, including the States. And many of the data falsification cases have been going on for a very long time, and employees continuing in a customary manner with no or little awareness that they are violating compliance. Therefore, continuous education, awareness raising of the whistleblower program, which I will touch upon later, and strong message from the top management need to be utilized. Next, I'm going to briefly explain about the bribery risks in supply chain. So according to the statistics by OECD, 75% of bribery cases against foreign public officials involve payment through third parties, such as agents or sales representatives. In response to the situation, the US FCPA guidelines and the UK Bribery Act stipulate the need for risk-based due diligence on third parties. Thus, the regulation for dealing with the risk of third-party bribery should be strengthened. There are some recent cases in Japan regarding the bribery in the supply chain, and one of the recent notable enforcement is that the bribery case where two professors of medicine were charged last year under receiving bribery from a medical equipment manufacturer. The case was widely reported in Japan, partly because the scholarship donation, which was internally approved in the normal process of the manufacturer, was found to be illegal later in the criminal proceedings. Further, recently, there have been issues of business entertainment from private companies to the ministries. The National Public Service Ethics Law prohibits national public officials from accepting gifts of money, goods, real estate, or entertainment from interested parties. And even if there is no such interest, national public officials at a certain level or higher should report any gift, entertainment, or other benefit of more than 5,000 yen, which is around 41 US dollar in value. Although this law does not directly regulate private companies or their officials and employees, there is a reputational risk that the name of the private company may be reported in the event of the violation of the National Public Service Ethics Law, in addition to other risks such as suspension from public bidding. As for the bribery of foreign public officials, METI revised its guidelines in May 2021. The Japan law does not explicitly provide an exception for small facilitation payments. Therefore, the revised guideline clarified that the provision of money or other benefit to foreign public officials, even in small amounts, is a violation of the act if the purpose is to obtain a wrongful gain in business. Next, I'm going to talk about how to identify for the company to the risk of in the supply chain. There are some perspectives on the supply chain risk assessment. First, geographic scope of supply chain. There are some country-specific indicators publicly available, such as Corruption Perceptions Index of Transparency International for corruption risk, and the Global Slavery Index for human rights risks. As for the sector business-specific risk, certain sectors and industries may have higher human rights risk, including extractives, textile, fishing, electronics, and agriculture. For bribery risk, if the business has many transactions with the government agencies, or if it is important to obtain permits or approvals from government agencies, the risk is higher due to the nature of the business. Also, as for the nature of the supply chain, the larger or more complex supply chain is, the harder it can be for a company to identify and monitor inappropriate practice in general. In addition to those perspectives, a company may also want to evaluate the impact of the sector or business when prioritizing the scope and the supply chain investigation. It is important for a company to conduct a supply chain risk assessment investigation and identify the high-risk area of business and supply chain. Also, if individual risks are identified in course of the investigation of similar cases in the supply chain will be also required. There are some challenges in relation to the supply chain investigation. First, to identify suppliers is the first step of the investigation, but not many Japanese companies have visibility into their supply chain. In particular, it may be difficult for some companies to identify tier 2 suppliers and beyond, so a system to visualize the supply chain can be a challenge. Also, there may be a gap between local laws and international standards of human rights. Especially in emerging countries in the supply chain, compliance with local laws may be criticized as an insufficient protection of human rights from an international norms perspective. It may be difficult to identify such potential gaps in advance, but engagement with stakeholders and the case studies of other companies may provide some hints for a company. Engaging outside experts would also be an option. Additionally, in many cases, on-site audits have been difficult to conduct in the situation of COVID-19, and companies must rely on questionnaire checks or remote implementation. However, companies should understand there may be a limitation for such remote review and should consider deeper review for high-risk areas. Also, some companies are passive or reluctant to communicate regularly with external stakeholders in the supply chain, like NGOs or local residents. However, regular dialogue may help to address problems before they become big issues such as lawsuits. So a company may consider the regular communication in the risk assessment process. Next, I'm going to talk about the whistleblower system or grievance mechanism. Japanese whistleblower system have traditionally targeted only internal employees. However, ESG risks could be detected earlier by including business partners, subcontractors, and other stakeholders in the grievance mechanism to allow them to claim to the mechanism. As for the challenges of grievance mechanism, stakeholders may include employees, business partners, local residents, and others whose native language is not Japanese or English. On the other hand, setting up a multilingual contact point will be a burden for the company. So there remain challenges for Japanese companies. It is reported that there is a movement to establish a grievance mechanism that can be used by multiple companies, but we will see the progress. In relation to the whistleblower program in Japan, the Whistleblower Protection Act was revised in 2020 and will take effect in June this year. Under the revised act, the companies with more than 300 employees must establish a reporting mechanism to respond appropriately to whistleblower reports, and the failure of such obligation may be subject to the administrative penalty. Small and medium-sized companies with 300 or fewer employees are obligated to make a best effort. In order to ensure the effectiveness of obligation, the revised act provides administrative measure, including instruction to companies. If a company does not follow such administrative instructions, the company name could be publicized. Also, the revised act requests a person who is engaged in an internal investigation to protect the confidentiality of information that could identify the whistleblower. The violation of such obligation is subject to criminal sanctions. I'll finish with some tips for effective reporting systems. As for the usability, an anonymous reporting option should be available if a whistleblower desires to do so. An increasing number of companies are establishing internal and external contact points in terms of accessibility for their employees as well. For the independency, responses and investigations related to internal whistleblowing must be conducted independently of management, especially for the cases that possibly the management is involved. For the global use, for the overseas subsidiary and other foreign stakeholders, it needs to provide local language support. Also, companies need to secure the requirements under the local law for the collection of personal data and the transfer of the data. We'll talk about this more in the next session. So thank you very much for listening, and we'll invite Hayakawa-san for the next discussion.
Okay, let me share our slide. Okay, thank you very much, Ayumi. So in the third part, so as I mentioned at the beginning of our seminar, so we have our sessions dealing with the hypothetical, so which is it looks like typical cases where global company has to conduct an investigation in Japan. So first of all, so Takeshi, so please, would you like to make your self-introduction?
Yes, my name is Takeshi Hayakawa, a senior associate at Nagashima Tsunematsu, and I have experiences in Japanese Data Protection Authority, PPC Japan, and I'm focusing on data privacy issues in this firm. That's all. And now I'd like to introduce Japanese data protection legislations in the context of investigation in this seminar.
Thank you, Takeshi. So Takeshi and I have conducted many investigations and cybersecurity incidents in Japan, and so we must always cooperate with each other to provide legal advice. So especially in sensitive cases where the transfer of information from Japan to other countries are problematic. So let's move on to the hypothetical in this session. So I think for the audience, it's better for me to read it. Okay. So the company X is a global company that manufactures and sells medical devices and is listed in the United States. The company has a Japanese local subsidiary with about 100 employees, which is mainly responsible for sales of medical equipment in the Japanese market. The Security Exchange Commission began investigation, investigating violations of FCPA arranged by a former employee of company X's South American establishment. If we filed a whistleblowing accusation with the SEC that X had handled over travel tickets and expensive golf goods to doctors at a national hospital, so in certain country between 2018 and the end of 2021. Subsequently, the scope of the investigation was expanded to investigate whether there were similar programs and practices in sales activities in Japan. So as mentioned, so it looks like typical cases, global companies so there's a head office in the United States and many subsidiaries all over the world, including Japan. So which has to have an investigation in Japan. And the typical stream is like this. So we got a call from U.S. counsel. So and ask if we can conduct an investigation for U.S. companies, and there's an allegation, and the government in the United States asked them to conduct an investigation or risk assessment regarding the practices in Japan. So before moving on to the specific questions regarding data privacy, so I'd like Ayumi to briefly explain the practices regarding data preservation in Japan.
Sure, Kamiji-san. So it is very common in Japan to conduct the data preservation and the consequent data review at the first stage in the investigation. So the scope of the preservation varies depending on the seriousness of the case or the form and duration of the data storage, internal rules, and other factors. In addition to the data in company server, which is usually be preserved, and in addition to that, if the retention period of the server is limited, or if the data is stored separately on individual devices, the individual devices may also be considered for the preservation. Further, different communication tools from emails, such as LINE or Slack, are increasingly used for internal and external communication these days. So these data may also need to be preserved. That's all from me. Thank
you. So let's move on to the questions regarding data privacy. And the first question, to Takeshi is that, so what should be noted from the viewpoint of data privacy? So when preserving evidence, such as communication, emails among salespersons, and the reporting to the boss, and should the subsidiary, so in Japan, obtain consent of its employees? So could you, please explain these questions?
Sure. And in this case, what is important in this situation from the viewpoint of data privacy would be whether the Japanese subsidiary needs to obtain consent of its employees for the data preservation, and more specifically in relation to the purpose of use of the Japanese subsidiary, and also provision of personal data to a third party, in particular to a forensic company, including the cross-border data transfer. And first, regarding purpose of use of the Japanese subsidiary, under Japanese law, more specifically, the Act on the Protection of Personal Information, which is called the APPI in short, the Japanese subsidiary may use the personal information within the purpose of use specified in the subsidiary. And also, if a Japanese corporation would like to use personal information other than the specified purpose of use, in general, obtaining consent is required. However, there are certain exceptions here. For example, if it is difficult to obtain consent of a data subject, and also there is a need to protect a person's life, body, or property, And such person includes a judicial person, and therefore such exception includes protecting the property of the Japanese subsidiary or company X in this situation. But complying with laws and regulations in other jurisdictions is not a justification in itself. And therefore, even a case where the Japanese subsidiary does not specify that personal information will be used for investigation purpose, the Japanese subsidiary may rely on such exception if it is difficult to obtain consent of its employees, and also there's a need to protect its own property. The next point is about providing personal data to a third party, including cross-border data transfer. Under the APPI, as a general rule, if a business operator provides personal data to a third party, such business operator needs to obtain consent of data subjects. However, there are exceptions for this. For example, if there is an outsourcing relationship with the third party and also such third party processes personal data on behalf of the business operator does not need to obtain consent of data subjects as a result of such outsourcing relationship. And as for the engagement of the forensic company, in this case, it will be an outsourcing relationship, and thus such exception will apply, and the Japanese subsidiary does not obtain consent regarding the provision of personal data to the forensic company. In addition, if the forensic company is not established in Japan, Japanese subsidiary should also care about the restriction on the cross-border data transfer. Under the APPI, the transfer to the EEA and UK is out of the scope of the cross-border data transfer restriction. However, the transfer to other countries, such as the US, as in this case, usually needs obtaining consent of data subjects or executing certain contract with the third party to ensure the level of protection of personal information, which conforms to the purpose of the APPI. And in this regard, the engagement of the forensic company in a foreign country will usually rely on the contract arrangement, but not on the consent of data subject. If so, the Japanese subsidiary does not need to obtain consent of data subjects with respect to cross-border data transfer. However, it is important to note that unlike EU SCC, there is not any template under the Japanese law regarding the contract regarding cross-border data transfer. And therefore, business operator in Japan should assess whether a particular contract between the outsourcing company meets the requirement under the APPI on a case-by-case basis. And assume that there would be an existing arrangement regarding transfer from the Japanese subsidiary to the headquarters of company X. And it is desirable to check this point in the course of conducting internal investigation in the context of cross-border data transfer.
Okay, so let me ask so one question. So you mentioned that the Japanese subsidiaries have to supervise the forensic vendor. So if they transfer their information or they ask forensic investigation to forensic vendors. So what kind of activities they are required as a to supervise the forensic vendors?
Regarding the supervision of outsources company, the Japanese law APPI requires to supervise the outsourced company. For example, how to select the appropriate vendor and also executing certain contract to manage the outsourcing work. And there is no mandatory matters to be included in the outsourced contract with APPI, but usually there are some provisions to be included in such a contract.
Okay, thank you.
And also, I'd like to add some points about the cross-border data transfer regarding amendment of APPI, because the APPI will be amended next month, just within a week. And there are additional obligations for the cross-border data transfer in Japan, and they are unique obligations in Japan. And so the amendment of the APPI will take effect next month, and also the amendment imposes additional obligations for cross-border data transfer. And if a business operator would like to obtain consent of data subjects regarding cross-border data transfer, the business operator should provide information on the legal system to protect personal information in the foreign country, including legal system of so-called governmental access or access by public authority, and data localization that affects the rights of individuals, and also whether the third party complies with OECD privacy guidelines. In addition, in the case of relying on the contract arrangement, the business operator should take necessary measures that such contract arrangement continues to ensure the appropriate level of protection. In particular, a business operator should check the legal system of the foreign country and also compliance status of the third party periodically, at least once a year. And further, the business operator should provide such information to a data subject when requested by the data subject. And as for the informational legal system in the foreign country, the Japanese Supervisory Authority Personal Information Protection Commission, which is called PPC, provides information about certain countries' regions, including the US. And therefore, in practice, business operators in Japan rely on such information regarding the cross-border data transfer. And moreover, if the personal information is stored in a server outside Japan, the business operator should understand the legal system of such foreign country. In addition, if necessary, the business operator should take necessary security management measures. In this regard, the Japanese subsidiary needs to check whether a forensic company is established in Japan or abroad, and also whether the data is stored in Japan or abroad.
Thank you. So, yeah, so for me, it looks like the amended, so personal, so APPI is much stricter than before. And so you mentioned that so the company should take necessary measures so in the contract arrangement to continue to ensure the appropriate level of protection. So in reality, it is not clear for companies, so what kind of measures to be taken. So do you have any ideas about that?
Yeah, sure. As for a global company, there are cases where the EU SCC will be customized for Japanese context, and not using the EU SCC itself, but amending some provisions for a Japanese version. And sometimes we will add some additional obligations under Japanese law in the EU SCC model.
Okay, thank you. So Ayumi, do you have any comments on that point?
Nothing from me, thanks.
Thank you. Okay, so and another question, so which is so very problematic. So in an internal investigation in Japan, so there are a lot of so important information stored in private devices, such as cell phone of salesperson. So, and when dealing with or preserving this in order to get evidence or get information from private devices of employees. So how to do that, or so what kind of legal assessment? So we need to be really careful. So Takeshi, do you have any advice or comments on that point?
Sure. Regarding the collection of personal information of the private devices, the collection of such devices needs careful consideration of the privacy of employees. And under the APPI, if an employee voluntarily submits the private devices, it'd be possible to include personal information in the private devices for the data preservation. However, even if the employee voluntarily submits the private devices, business operator should also care about employees' privacy. Even if a business operator complies with the APPI, under the civil code, there'd be a possibility that compensation for tort claims may be granted if certain processing personal information is regarded as infringing upon one's privacy. In this regard, if a company allows BYOD bring their own devices, it is desirable to make specific policy for BYOD and obtain consent of employees in advance.
Thank you. So Ayumi, so I have one question. So in the real practices in Japan, so it looks like these subsidiaries are relatively small companies, and the governance and internal rules are not so well prepared. So could you please explain the reality in Japanese investigation? So whether they prepared good policy or rules to obtain the consent from employees.
Sure, thank you, Kami-san. Yes, we often having difficulty in persuading employees and officials to consent for the data preservation of the devices or their individual devices, especially where the internal rules is inadequate. And it depends on the seriousness of the matter. But we have to have a reasonable decision considering both the seriousness and materiality of the cases and the potential risk of the future litigation or claims from the employees. But yes, this is very difficult decision to obtain a consent in many cases.
Thank you. So yeah, I do agree that, and in a reality, so in a daily cases, so we have faced a lot of challenges. So obtaining the consent from employees, and also so for companies where the head office is in the United States and the Japanese subsidiaries are relatively small, so it is hard for them to prepare in the first day of the operation to prepare the good internal rules. So including the policy of privacy, private devices, and rules to obtain the consent from the employees when making a contract with sales employees. So I think so it's better for global companies so considering to expand their business in Japan. So I think so in order to ensure a good governance system, so in Japanese subsidiaries and good compliance programs in Japan, so to prepare for their privacy policies, including how to deal with private devices. So the first day of the operation. So since it is really important when identifying some misconduct and potential misconduct and need to be investigated. So let's move on to the next topic. Which is a questionnaire investigation and data privacy. So Ayumi, so before digging into the data privacy issues, so could you please briefly explain the use of questionnaire in the internal investigation in Japan?
Sure. So in course of the investigation, questionnaires to employees may be used to identify similar misconduct, or the questions may be asked about the company's culture or environment so that the result will be incorporated into the investigation report as a part of cause analysis of the misconduct.
Okay, thank you. So Takeshi, so how to deal with the data privacy risks when conducting questionnaire in Japanese investigation?
Sure. And as I explained earlier, a business operator may use collected personal information within the specified purpose of use. And if a business operator collects personal information directly from the data subject in writing, such purpose of use should be indicated to the data subject. In other cases, publication of purpose use, such as by making it available on the website, would be sufficient. And in this regard, in practice, the purpose of use for the questionnaire investigation is notified to data subject through the announcement of questionnaire. In addition, in the case of the questionnaire investigation, such questionnaire can be accessed on the internet, and employees will read and understand the explanation before answering the question and provide clear consent for the use of personal information, including the submitted questionnaire. In addition, there are several ways of collecting personal information. One option is that the Japanese subsidiary itself collects and uses personal information. And another option is that a third-party committee, which Kami-san mentioned earlier in his presentation, and collects and uses such personal information. Either way is fine, but the identity of the entity who collects personal information should be notified to data subjects. Moreover, if processing of personal information involves provision of personal data to a third party and entity relies on consent of data subject, such matters should be included in the notification that I mentioned earlier. In particular, it is often the case where the result of the questionnaire needs to be transferred to a counsel in other jurisdictions like in the US in collaborating the investigation process. Therefore, if such transfer relies on consent, the consent made by the data subject should cover such transfer.
Okay, thank you. So, yeah, what about the hotline, which is also generally or widely used in Japanese investigation? So Ayumi, so would you like to explain the use of hotline briefly, please?
Sure. So hotlines are also often set up with outside counsel as a point of contact during the investigation. It's regardless of whether a questionnaire is used. And the hotline allows anonymous reporting and is used as a means of investigating the existence of similar or other unidentified misconduct. Sometimes we received many claims through hotlines, and I experienced one case where the hotline was used to report the kind of obstruction in the investigation, whereas supervisor instructing an employee not to tell truth to the attorney about the misconduct.
Thank you. So in reality, so I have faced many cases where there's no hotline used for 3 or 4 years, but so at the beginning, so when we begin an investigation and set up a hotline, so to confirm if there are another cases or wrongdoings in other businesses or similar misconduct in other businesses. So based on the root cause analysis and the structural issues we identified during the investigation. And at that point, so as Ayumi mentioned, so there may be several reports to investigation committee or council for such as us. So in Japan, it looks like very hard for employees to blow a whistle because so there is a employment environment, so-called long-term employment or lifetime employment, which make it really hard for employee to report something not comfortable for their boss because the risk to be excluded from the company is quite high for Japanese employees. And as you know, it is like a family. so many researchers describe Japanese companies as family members, and it is something very positive. So to work together and cooperate with each other to achieve the specific goal in a positive manner. But at the same time, so when dealing with these kind of compliance issues, sometimes that kind of strong and tight relationship make it difficult for employees to speak up the issues to their company. And also, it could be a good justification for employees not to report to the company, so because they are family members. So, and this kind of reality and so cultural background should also be well understood when conducting an investigation in Japan. So let's return to the question regarding hotline. So Takeshi, do you have any comments from data privacy perspective when dealing with hotlines?
Sure. Basically, the principles under the APPI are the same in the case of hotline, unlike in the question investigation. So I don't have any things to add in the context of hotline.
Okay, thank you. So we can, so it could be said that, so when dealing with hotlines, so the same assessment should be done when conducting questionnaire investigation. So, okay, thank you so much. And let's move on to the next question, which is an interview and data privacy. So Takeshi, so in this kind of investigations, so in this case, there are 100 employees and there may be 10 or 15 sales people in this company. And it's quite important to have an effective interview with these guys. And would you like to make some comments or points to be in mind from viewpoint of data privacy, so when conducting an interview?
Sure. And in the case of an online interview, in the course of conducting investigation on Japanese employees, there are cases where lawyers in other jurisdictions participate in the online interview for the ease of the smooth investigation. And for most cases, the privacy risks would not be high under Japanese law if the identity of the lawyers are clearly indicated to the interviewee.
Great. So I have a a kind of tricky question or a kind of ridiculous question. So I think due to the pandemic, we need to have online interviews, as we mentioned in the earlier sessions. So what about the situation? What about the situation where there is a U.S. counsel or the employees in the U.S. head office who want to join our interviews conducted in Japan, and they want to have an online access to our interview, so even though we have a face-to-face investigation or interviews with employees, so there's a Teams or Zoom window, and the U.S. people are joining in the interview. And of course, we need to ask many questions in details, including some names of individual or some sensitive topics during the interview. So is there any risk or problems when having online sessions like this?
Yeah, in such a situation, the collection of personal data by the US headquarters could be regarded as a data transfer from the Japanese subsidiary to the US headquarters. In that case, the restriction on the cross-border data transfer should apply, and there needs to be some arrangement regarding enabling the cross-border data transfer, such as by having a common privacy policy between the Japanese subsidiary and also with the US headquarters, or executing some contract between each party.
Right, thank you. So we don't sometimes care to invite someone from other countries when having interview, because usually investigation plan is really tight, and in a tight schedule, we need to have an investigation, including many interviews with employees. So we need to be really careful in conducting an interview. Because online interview could be sometimes very risky and could be regarded as data transfer from Japan to abroad. Thank you. Okay, so let's move on to the next topic, which is document production and data privacy. So Ayumi, could you please explain, in what situations we need to produce evidence or facts to government authorities?
Sure. So in many cases in the situation, we need to provide the document to the authority. Sometimes we have to prove that the misconduct is not very severe, or we need to provide evidence to support the testimony of the employees or officers. Or other cases, the government may request us to provide the supporting documents and evidence to prove the misconduct. And also, in many cases, we have to deal with the foreign regulators in a similar way. So we need to provide with the supporting evidence to the US or other jurisdiction regulators as well.
Thank you. So in that regard, Takeshi, so what kind of point to be noted? So when considering to produce evidence or supporting document to government authorities from data privacy perspective? Sure,
and although I'm repeating this term several times in this discussion, and there is a restriction on the provision of personal data to a third party, and also on the cross-border data transfer restrictions under the APPI. In this regard, for the submission to a foreign authority, the APPI generally requires the company to obtain consent of data subject. And it is important to note, to take into account that the complying with laws and regulations in other jurisdictions is not justification itself. And one way to avoid such restrictions is to submit documents which do not include personal data, such as by deleting certain information in the documents so that a specific individual cannot be identified from those documents. However, such a way is not always possible, and therefore such restriction could be regarded as blocking statute in certain situations. Having said that, if it can be an option to rely on an exception for obtaining consent of a person of the data subject under the PPI. In particular, as I also explained earlier, if it is difficult to obtain consent of the data subject, and also there is a need to protect a person's life, body, or property, obtaining consent is not required. And therefore, this exception can be used in such a situation.
Thank you. So in my impression, it is really hard to get consent. So at the stage, where we need to produce that evidence or supporting document to the government authorities. So, and if I were an employee, and I was asked if it is okay to produce a really good evidence emails, which I wrote to my colleagues that there's some sensitive communication, I would say no. And please refrain from sharing that document to the government authority. So it looks like obtaining consent is not realistic. So what kind of measures to be taken in order to mitigate the risk of data privacy violation in that kind of situation?
So in this situation, one option is to delete some information in these documents I explained earlier, or utilizing the exception as for obtaining consent to have evidence that there is a necessity to submit to the foreign authority. And if the company does not submit the documents, there are some sanctions on the company and damage the property of the company. It can be some proof for as evidence or falling into the requirement of the exception under the API.
Great, thank you. So I have a tricky question. So if the company would lose really good opportunities to cooperate with their government investigation, and that could be higher sanction imposed, that could be triggered or higher sanctions, and so in that case, that kind of potential loss could be an exception under the Japanese law, without in order to skip the consent from the employee.
So it's a difficult question, and as far as I understand, there is no enforcement cases regarding the cross-border data transfer by the Japanese Data Protection Authority. And if I were in a position to advise in such a situation, I advise clients to use the exception because there's a necessity to provide the documents to the foreign authority in order to protect the company's property.
Okay, thank you.
Awesome.
Okay, so I think so the time is coming, and so we have several questions from chat box, and Ayumi, would you like to take some questions?
Well, I think Fukami-san can add your views, but the question about how to manage the confidentiality for any online session in interviews, as Fukami-san said, we can ask questions about the environment of the interviewees, but maybe I'll suggest the in-person interviews if the confidentiality is very severe and we want to make sure the confidential situation.
Yeah, I do agree that. So, and I think, so what kind of questions so we need to ask? So in that question is very problematic, and it's a question. And if we need to ask very severe questions, so I think so we need to give up having online sessions. So, and invite them so to our in-person interviews, even though, so even in the midst of pandemic. So, and also, so at the beginning of online interview, so I usually ask some questions regarding the situation. So, and he or she is now in an interview on their side. So is there anyone around you, or is there a door is closed? So, and this kind of several simple questions could mitigate the risk to some extent. So Takeshi, so I think another question is for you. Can you repeat the name of the model for contractual protections for cross-border transfer of data?
Yeah, and under Japanese law, as I explained earlier, there is no model clause for enabling the cross-border data transfer, but actually the EU STC issued by European Commission, that is the standard contractual clause, that is a global company often use. And if I were requested by the client to prepare documents for enabling cross-border data transfer, I revised the European Commission's EU standard contract clause and omit some provisions or add some provisions and customize the contract for the APPI context under Japanese law.
Okay, thank you. So I think, yeah, so it's time to conclude. So, and yeah, so we are happy to answer questions from chat box after our session, and happy to send an email so separately. So thank you so much. So coming to this webinar. So okay, so yeah, please close this session, and thank you so much.
Absolutely. So yeah, there's a few more questions in the chat, but as you know, Daisuke said, he will address them via email. Thank you very much. That was very interesting, very useful indeed. A huge thank you to Nagashima Ono and Tsunematsu, Ms. Fukuhara, Mr. Fukimitsu, Mr. Hayakawa, and to our audience today. I hope to see you at another webinar shortly. And goodbye.
Thank you.